Jay Abt, Your Honor, good morning, on behalf of Mr. Kendrick, and I'll try to be extremely brief. Your Honor decided this issue in lieu of granting a mistrial, and one of the things I want to remind the court, really I'm just here to remind the court, is one of the reasons for this sanction, Your Honor, is because of, and I'm not pointing fingers in particular district attorney, but the state's repeated unpreparedness, their repeated discovery abuses, and so this is a compound issue. And I think my perception is that the court finally had to say, okay, we're not granting a mistrial, but we got to do something. And if you now go back on that decision and reverse your own decision, you are essentially creating an incentive for the state to continue these, I'll call them mishaps, whether they're negligent or intentional. And I think the court has sent a clear and convincing message to the state that they need to be buttoned up, more buttoned up than they have been. And so I would ask the court, certainly the court has the authority. Mr. Steele's done a very good job of explaining that, but I would ask the court to uphold its own decision to send that loud and clear message. Thank you, Your Honor.
Thank you. Mr. Armstrong.
Yes, Your Honor. I would agree with Mr. Abt to the point that I would like the court to uphold the determination that the court made, which was that it was not an intentional, willful act, as Mr. Steele has argued. I want to address both of the two cases that he referred to, Illinois versus Allen. One of the issue in Illinois versus Allen was a defendant who refused to act with decorum and was excluded from the courtroom, but was permitted to come into the courtroom if he was going to behave correctly. And so it went specifically to the offensive behavior for as long as the offensive behavior went on. We are asking the court to, the court appropriately struck the testimony that was at issue. We are asking the court to go further with other testimony that was not the offending testimony. Now, People versus Navarrete is the only case the defense has cited to suggest that this specific remedy was permitted. That is a nationwide search in People versus Navarrete, Navarrete, is the only one that they were able to cite, and that is materially different in a number of ways. Number one, the facts are wildly different. The officer in the case was mad at the judge for excluding a statement that the officer had obtained, and actually had told people that when the prosecutor found out, told the judge after the fact, when they found out, that the officer had basically said he was going to do this because he was mad at the judge and would show the judge what for. That is not anything what happened here. And the reason that the appellate court in California decided that a mistrial was necessary in that circumstance was because of the specific evidence in that case, which is basically three things. You had a witness testifying the defendant had committed lewd acts against them. You had somebody testify they took about, I think it was a dozen or more swabs relevant to that. And then you had the officer testify, oh, I didn't think it was relevant to get the swabs because of the statement the defendant made that I can't talk about. The officer specifically said that because it would prejudice the defendant. And those are the circumstances in which it would, in fact, be incapable for a court to take that away. I would note before I go on to my main point about People versus Navarrete is that the California appellate court stated, we note that a trial court can almost always cure the prejudice of an improperly volunteered statement by granting a motion to strike and charging the jury with an appropriate curative instruction. This court did exactly that. It was just the exact facts, how thin the state's case was on that issue, on basically the entire case, and the reason for it was why they decided a mistrial was necessary on appeal. More importantly, this is the case that they cite that says the remedy of preventing Detective Dennis from testifying further. This is the case that they use for that proposition. At no point in this decision does the appellate court address the legality of that. They simply don't do it. It is not addressed whether that was a legal remedy to occur. It's not something that stands for the proposition that the defense is citing it for, which is that the remedy to prevent Detective Dennis from testifying further is appropriate. And so they have not pointed to any statutory or constitutional authority, and under Rule 402, the exclusion of evidence can exist outside of that in the state of Georgia. Now, I'm sure, let me just strike that. So we're just asking that the detective be able to testify further in the case when the prosecution team determines that he is the person who's best able to testify to facts that are relevant for the jury's consideration.
All right, thank you. So I don't think that the facts in the California case are really that different than the facts here. Frankly, I think that an argument could very plausibly be made that the detective in this case was upset with somebody about his qualifications having been challenged and had made a decision that he was going to show somebody what he thought about that. I don't know that that's what happened, but I do think, like I said before, that the detective absolutely knew better than to have said what he said and did it anyway. And I have given consideration to everything that has been presented, but I am not going to change my decision about this. All right, I think that the next thing that...
Good afternoon, everyone. Welcome to the channel. It's your girl Mocha here. We're doing a recap of today, as it's still going, but couple of things of note today. So officially, the DA's request to have Detective Dennis come back is not moot. I think is what is how they refer to it. It's flat out denied. Yeah, and Paige Whitaker, the Honorable Judge Paige Whitaker, said exactly what we were all thinking, and maybe still didn't argue it to this T. He did say he felt like it was purposeful, but what Paige Whitaker said was he may have felt like them questioning his questioning him as an expert. His expertise were on the line. And maybe he didn't appreciate that. And maybe because of that, he decided to get a slick one in. I will remind you, and I said this in my live this weekend, if you go back and watch his previous testimony, both him and Gaither, they threw up a bunch of slick stuff during their testimony. I would draw your attention to specifically when Max Shard is questioning Gaither on the stand, and he's asking her a question, and she made a very particular statement, and Judge Glanville did absolutely Nathan about it. She said, and you're forgetting, sir, that members of YSL shot this boy in the head. Judging by the judge we have now, that may have been grounds for a mistrial then and there. But the judge we had then let that ride out. He didn't do nothing about it. So it was kind of like, I was remembering that as they were kind of discussing, why he may have done what he done, how they brought in someone else to argue that point and to write up their motion in limine. It was a request to kind of like overturn your what you had said. I can't even think of the name. Sorry, my brain just goes blank. I just worked a full 8 hours plus 12 yesterday, so my brain is like but anyways, yeah, so that was like a plus. But can we give it up for Jay Apt on Doug Weinstein's co-counsel that literally was going argument for argument with Detective Underwood? Like, that was, we kind of here for the messiness. We act like we ain't, but we are. We are here for the messiness. This whole trial is a wrecking ball, and we here for it. But that was interesting. You every now and then you see Jay come out the closet with, when he arguing some stuff. And so that was interesting to see him arguing down lyrics. And he had a point. Who are you to judge what they mean, what they say? What they mean by what they say? You know what I mean? Like, okay, they qualified you as an expert in gang lyrics, but you just said out your own mouth that you were making decisions about who was involved based off of the lyrics that they wrote, but nobody went and pulled Woody's video. Nobody said, oh, there's some similarities in the characters in this video compared to what happened. The character looks real familiar. Who? This person was a person of interest. Nobody? Can we get a nobody? So that was real interesting. We're now getting into Little Rod's situation. Me personally, I completely oppose the Little Rod. His convictions even being on this trial, just because I know that they're using this to inflame the jury. For no other reason than that. Because it's already been, half of them's already been convicted of stuff. But, the stuff that they have no one convicted for, they're just going to throw on here because they need to get these cases closed out. And then the Little Rod stuff, which they've already convicted them of, is the age of the victim and the people involved is what they want to use to inflame this jury. And they're absolutely trying their hardest to accomplish that. It's really interesting, though. We're going to see this keep happening over and over and over and over again until, the state gets what they want. Sorry, that was Big T. Open up the door. They want to emotionally draw in the jury to say, oh, but can they prove that this was done at the behest of, at the direction of YSL? Or if this was some young kids on their own stuff doing it for their own reasons? Do we even know why this was done? Or for what? For why, as my babies say. For why it was done. We'll see. Today was not really a rant to full day. Um, but I'll add some clips in here and try to make it juicy for you. I appreciate you guys. The live this past weekend was amazing. I loved being able to talk to all of you and you guys being able to talk to me and you guys getting to hear some of my opinions on why people doing what they're doing. I'm going live again this coming Saturday at 2. So stay tuned for that. Like, share, subscribe, turn on your notification bell so you will be hit up when I'm coming through. Yeah, let's see where this thing goes. Let's see where it goes. I wish I had more for you today. But today it was just kind of like, Detective Underwood really, I will say this, Detective Underwood, I don't feel like she was as involved with this side of the YSL and knew of. What she had a lot of is speculation. She had a lot of, well, I think this means that, and I think this happened because, and I think you putting this in a song 5 years later meant this, but who knows? So I don't know if that was a good idea for the DA or not, but they're going to do what they can do while they can do it, and they're going to try to lump as much as they can together because that's what they're here for. But hey, until next time, peace out, y'all.
Wax. Does that mean we don't speak on record? We don't go on something that's permanent to talk about mob business? Is that fair to say?
Yes.
But then this entire song is about criminality, or most of it. I won't say all of it.
The song kind of, it talks about the beef that, or the interaction at Lennox, which happened. They tell you to ask the cops, the detective, they know all the business. So, on one hand, he's saying that we're not going to talk about it, but we talk about it.
That's my point. So it's interesting in that song saying we're not going to talk about anything, but yet it's being talked about, right?
Yes.
You don't know whether any of this music, these lyrics, I know you don't know who wrote them, but you don't know if they're just art, do you? And not autobiographical.
It can be art. It can be looked at as art. I agree that it's art, but I think that when actual crimes are committed and you brag about it in a song, or you reference it in a song, or you taunt your ops in a song, then it causes problems. Because like I said, I've seen where songs have gotten 12-year-olds, 14-year-olds killed here in Atlanta because of things that were said in a song.
Well, that's terrible. But where in any of these songs that you looked at does it mention the op means opposition? Fair to say?
Yes.
Where does it ever mention IF gang?
What?
IF gang.
It does not.
I mean, that's your, and you're entitled to, but that's your opinion. That's your personal opinion, right?
Yes.
Okay. Where does any of these songs mention Jeffrey's friend Donovan Thomas?
It don't.
Now,
or sings about an act of violence that actually occurred, then it becomes obvious of what?
To me, it's bragging. Could be taunting or bragging.
And well, let me ask you this: are you aware of whether Mr. Kendrick wrote any of those lyrics that were played in the courtroom earlier?
No, I'm not aware.
So you don't know if my client was even involved in writing those lyrics.
I never said he did.
And you're not aware of Mr. Kendrick in any way, shape, or form being tied to or involved in the murder of Donovan Thomas. Isn't that true?
I know he was arrested and charged or a suspect for it.
Were his fingerprints found anywhere?
I didn't work the homicide portion of that. You would have to refer to.
You don't know. You don't know if his
I didn't
fingerprints.
get into the homicide investigation.
You don't know if his fingerprints were found on the Tahoe or any evidence in the case?
No.
You don't know if his DNA was found?
No.
You don't know if any ballistics were found that were tied to Mr. Kendrick, correct?
No.
In fact, you're not aware of any eyewitnesses who saw Mr. Kendrick commit that crime, correct?
I don't know of any.
And you went to great lengths to give an expert opinion about what the state refers to as Exhibit 535 YB, which is the song called Slime. And I apologize, I may be less genteel than Mr. Steele is, but it's a piece of evidence. The song's actual name is Slime Shit. Is that right?
That's correct.
Okay. And you stated earlier you don't know the date that song was released, right?
No, I only see the date that it was uploaded to YouTube, like I told Mr. Steele.
You don't know the date it was written?
I don't.
You don't know who wrote the lyrics?
I don't.
And so if that song, if I told you that track was released officially on September 16th of 2015, and that...
Sustained.
I'll withdraw the question. If, hypothetically, if those lyrics were released in 2014, before the murder of Donovan Thomas, then would it be fair to say that the Tahoe mentioned in the song had nothing to do with Mr. Thomas's murder, right?
That would be fair.
You're not suggesting that whoever wrote the lyrics was psychic and predicted the murder of Donovan Thomas, right?
I did not say that.
Okay. Thank you. I have no other questions.
All right, are there other defense attorneys with questions for this witness coming up?
Good afternoon, former agent?
No, I'm actually a retired investigator, but I was a former task force officer.
Retired investigator. Okay, retired investigator Underwood. My name is Max Shard. I represent Shannon Stillwell, okay?
How you doing?
I'm fine. How are you?
Good, good.
All right, good. First of all, I just want to get one thing out of the way. And I know you were answering a question. You brought up some Atlantic Station incident. That has nothing to do with this case,
Oh,
correct?
no, it has nothing to do with this case. It was just referencing gang violence.
Okay, cool. You, in preparation, you knew you were going to be testifying eventually, and you provided a CV
I did.
to the state, correct?
I did. It's probably been a while, though, since, because I might have updated it since I did my Daubert, maybe.
Okay. Yes, I understand. On Friday, when the state was asking about some of your background experiences, you were asked, have you received training on how gangs use music to promote violence? And you answered yes.
I have.
Okay. Could you tell me the name of that class and who taught it and when that occurred?
I have attended like the Georgia Gang Investigation Association training where, and I can't remember the name of the individual. I know Marissa Viverito has taught one at APD, but when I went to the GGIA one, I can't remember the name of the instructor, but I've had like at least 2 or 3 classes.
So Marissa Viverito is someone who worked for the DA's office in Fulton County, correct?
She used to.
And she's also worked for the state of Georgia, correct?
Yes.
And you know her to be on the witness list for this case, correct? Okay, so she taught that class.
She taught one of them.
Okay.
I've been to more than one.
Well, who specifically talked about how gangs use music? What individual, what professor, or was it an artist that talked about that? Who was it?
It wasn't a professor. It was law enforcement.
Oh, law enforcement. And who was the law enforcement?
The one that I do remember recently was Marissa. She teaches one. She taught one at APD.
All right, Marissa Viverito, who used to work for the DA's office. Okay. So there was no one from the music industry, no artists or anything there. Okay.
No.
How gangs? You were asked if you had training in how gangs use music to promote fear in other gangs. Again, who were the musicians or anyone that spoke to you about that?
No musicians. I think
Okay.
the classes that I've taken have been all from law enforcement when it came to gangs. My other classes at Columbia Southern were professors, but they didn't talk about gangs.
Okay. And the how gangs use music to promote fear in other gangs. What date was that? Who taught you about that?
I told you what class. I don't remember the instructor on one of them, but I do. Like I said, the most recent one at APD within the last 3 years. It might have been while she was still here. She taught that one. That's the one that stands out. But I did go to one down in South Fulton as well, but it was like a GGIA training.
You were asked how gangs use. You were asked about your training or education and how gangs use music to promote cohesiveness. Who taught that class? Is that the same
It
answer?
would be the same. Yes.
Okay, so no one from the music industry, and it
Oh,
seems
no,
like
every class was law enforcement.
and the one that you're speaking of is Investigator Viverito, who's on the state's witness list for this case.
That's one of them.
Okay. And the same answer would be for your experience when the state asked you how gang members use music to send messages to rival gangs. Would those be your same answers?
Yes.
Okay. All right. And then you were asked by the state here, among other things, to talk about lyrics in this case, and you've been speaking about specific lyrics.
Yes.
Okay. In that Bad Boy video, you didn't recognize the other artist?
No,
You
I don't
ever
know
hear-
who that is.
You ever hear Juice WRLD?
I've heard of it, but I don't. That's not anybody that came on the radar because he haven't probably committed a crime here in Atlanta.
Okay. So as I understand it, in preparation of this testimony, and correct me if I get the timing wrong, sometime last week, the state gave you some music videos to review or some songs to review.
Yes.
Okay. How many?
The 3.
Okay. It was just those 3.
Just these 3.
Okay. And they were all songs by Jeffrey Williams.
Yes.
Okay. Did they not ask you to review a song called Homicide, written and performed by Lil Woody featuring Fagiano?
Never heard of it. No,
Have you ever watched that video?
I haven't.
Okay. Are you aware of this song?
No,
You aware that in that music video, in that song, Woody talks about putting money on someone else's head?
not aware.
Are you aware that the person he talks about putting money on their head is a heavy-set African-American male?
Not aware of that.
Are you aware that the person he conspires with in that video to kill the heavy-set African-American male is Trevante Turner?